Hi, everyone. In this lesson, we're going to talk about Title VII of the Civil Rights Act of 1964. Okay, so this is that key piece of legislation that makes it illegal for employers to discriminate against employees for certain protected classes. So, what this means is discrimination in hiring, firing, training, promoting, discipline, or other workplace decisions based on, here are our protected classes under Title VII: race, color, religion, sex, and national origin. Now, later on, we're going to add some other protected classes under different laws, but these are the initial ones. Okay, so who must comply under Title VII? Employers, unions, joint labor and management committees, employment agencies, all government employers, and here's the key: private employers with 15 or more employees. Okay, if you have fewer than 15 employees, you aren't required to comply with Title VII at the federal level, but you have to just check for your state if there are state laws that would also mandate you to not discriminate against these protected classes. But we'll just talk about the federal law here, for example, for right now. So who's covered? Public and private employees at all levels, including management, U.S. citizens who are working for a U.S. company abroad, employees of a foreign company inside the U.S., undocumented workers, although they will probably be limited in the number and amount of remedies available to them if they actually win a case. Who is not covered? Private employees whose employer has fewer than 15 employees. Employers whose employers are not engaged in interstate commerce. This is going to be incredibly difficult to prove because almost every business is involved in interstate commerce in some way. But even if you successfully prove that you aren't engaged in interstate commerce, you'll probably still be covered under some state law. So don't just go thinking that you don't have to comply. Also not covered: non-citizens employed outside of the U.S. Businesses in or near Native American reservations are allowed to discriminate in favor of other Native Americans. Otherwise, they have to comply with Title VII. Religious institutions, especially when we're talking about positions with religious duties, we're generally here talking about discrimination in favor of members of that same religion. We also do see some churches that require certain positions only to be held by a man, for instance. So the government tries not to get too entangled with churches and regulating how they're practicing their religious beliefs. Bona fide private membership clubs. So here, the best example, or the easiest, the most accessible example of a private membership club is a country club. In order to join, you have to oftentimes be invited, have sponsors. It's private individuals who gather together to form this club. It's not always 100% guaranteed, but oftentimes going to be excluded from compliance with Title VII, although there will be other pressures on them to not discriminate in a lot of cases. But explicitly excluded and not covered under Title VII for reasons that go back into history and looking at the people that we needed to vote in favor of this legislation in order for it to pass. And people worried that we might be allowing, well, in this instance, given our history in the United States, a lot of wealthy white people were worried what might happen if they were forced to allow black people to join their country clubs. Just an unfortunate part of U.S. history, but that's part of the law here. Another historical artifact here is that communists are specifically excluded. We just have to think of when this legislation was passed, 1960s, during the Red Scare. People are incredibly worried about the influence of communism around the globe. and so specifically excluded here. Again, just for those political pressures that invade kind of all pieces of legislation, because you always have to get a certain number of people to vote in favor of something for it to pass, and sometimes you have to compromise on certain things here and there. So what if I think I have a good case to file a claim under Title VII? Non-federal employees have to file within 180 days of the discriminatory event. This might be extended to 300 days if I'm also covered under state law. If I want to be safe about things, just be sure to file a claim within 180 days of the discriminatory event. Otherwise, I might not be allowed to file based on the statute of limitations. The state law interface in the filing process. So most states have their own laws similar to Title VII. North Carolina is no exception. We have our own anti-discrimination laws. Many have their own enforcement agencies called 706 agencies. North Carolina's 706 agency is the North Carolina Office of Administrative Hearings under the Civil Rights Division. This is, well, we've had a little bit of shuffling around in North Carolina since HB2 a few years ago. It was a whole debacle. I won't go into the entire history here. We'll talk about it later. But the Human Relations Commission was relocated to be part of the Office of Administrative Hearings. I guess it doesn't really matter that much to you. I give you a link to where to file a claim in North Carolina. So the EEOC will defer claims to the 706 agency if one exists in that state for 60 days before investigating. So what we'll learn later is that if you feel like you've been discriminated against in violation of Title VII, you first have to work through this administrative process, filing a claim with the EEOC or the state's 706 agency, and allow them to do their investigation, work with the employer first before I can just go sue privately. And that's just the way that it works here in the United States. So proceeding through the EEOC. The EEOC, if you don't know, is the Equal Employment Opportunity Commission. It's a federal agency that is set up to regulate and enforce Title VII. So the EEOC will send a notice of the charge to the employer if I file a claim within 10 days of me filing that claim. Oftentimes they'll try to get us involved in mediation where if we voluntarily agree, both the employee and the employer, if we agree to mediation, then we can sit down and try to work out and negotiate some type of settlement here, whatever that settlement might be, in order to sort of quash this beef, whatever's going on, before we actually go to investigation and trial. We can issue a request for mediation at any stage of the administrative process. This is going to be very popular because a lot of times companies will try to avoid going to trial, avoid going to court, and avoid an investigatory process. So oftentimes they'll just sit down for mediation right away to try to figure out what's going on and see if we can settle this without it becoming blown up into a bigger deal than it needs to be. The EEOC investigation. So if mediation is not chosen or if mediation fails, the EEOC investigates by interviewing the employer and the employee, any available witnesses, viewing any available documents, maybe even visiting the workplace. And then after the investigation, they'll make a determination. So after the investigation, they make a determination whether there's reasonable cause for the employee to charge the employer for violating Title VII. And then either party will have the right to ask for reconsideration of the determination, where the EEOC reviews it again and then makes a determination. Okay, if I, as the employee, receive a no reasonable cause finding, then the employee is given a dismissal and a notice of rights, also known as a right to sue letter. Now, since the employee didn't win at the EEOC level, I have the right, the ability to pursue this claim in court within 90 days of receiving this notice. So now is when I can actually take it to a traditional court system and see if I can convince a judge or a jury that I've actually been discriminated against here. If we have a reasonable cause finding, so if the EEOC in their investigation finds that discrimination probably actually did occur here, then we bring the parties together with the investigator to discuss the findings of the investigation. The parties are given a chance to conciliate, in other words, try to find some solution here, try to negotiate some type of settlement, whatever that settlement might be. It might be getting a job back, it might be some amount of money, whatever it is. And if that fails, the EEOC can file suit in federal district court if it's deemed justified by the EEOC. So long story short here, if I feel like I've been discriminated against, I have to go through the EEOC first. If they find in my favor, then they'll bring a lawsuit on my behalf. If they don't find a reasonable cause and they don't think discrimination happened or at least can be proven, then they give me the letter that allows me to go sue privately in court. Judicial review, it's asking a court just to review the investigation and the documents and everything the EEOC came up with. This can be sought by an employee who is given a right to sue letter. The scope of review is going to be narrow, just looking for obvious mistakes that the EEOC made. Title VII requires the courts to accord EEOC divisions de novo review. So if I get this right to sue letter and then I go to sue in court, then they're not supposed to consider all the investigation and everything that the EEOC did, but treat the case as though it's brand new. That's what de novo means. Another thing to consider here is that mandatory arbitration agreements have become more common, which means that a lot of employees are giving up your rights to pursue claims through the EEOC or through courts. This is extremely important for people to understand. When I get hired on, a lot of companies are requiring employees to sign mandatory arbitration agreements, saying that rather than going through court or through the EEOC, we'll hire an arbitrator who will hear both sides' stories and then make a determination. And then most times that determination cannot be appealed to the court system. So it's just something we have to be aware of as employees getting hired or as employers considering these type of agreements. And it's not always 100% clear if I notify the EEOC and if they think that I actually have a good case, it might be allowed that the EEOC can bring a case on my behalf, but that I wouldn't be able to sue in court. We're still hashing some of the stuff out a little bit. So let's say I win. I've been discriminated against and I win my case. What remedies are available to me? We're looking at things like back pay, the amount of money that I would have been paid if I had stayed on at the job, or if I was denied a promotion, the difference between my current salary and the one that I would have gotten if I had been given the promotion. Whatever benefits I should have been paid out for during that time. Maybe reinstatement of my job if I lost the job. Although whether or not you still want to work for that company, up to you to decide, I suppose. Job placement. Injunctions. An injunction is just a court order for a company to stop doing something. If I've been discriminated against, they have to stop discriminating based on this. Attorney's fees, if I'm paying an attorney or if the government's paying an attorney to take up this case. Expert witness fees, if we have to bring in expert witnesses to testify. Court costs, these are all part of the remedies. Now, there are other possibilities. These compensatory and punitive damages are possible if the investigation reveals that an employer is intentionally discriminating. If we find out that the employer is acting so egregiously that we're going to award these additional types of damages that otherwise wouldn't be available. Things like, so compensatory damages, you're thinking things like emotional distress, medical expenses, cost of a job search, and other related costs that come out of pocket for an employee. Punitive damages are those designed to punish a company for willful acts or fraudulent acts or things like that. And there are federal caps on the amount that those damages can take, and it depends on how many employees a company has. So smaller companies between 15 and 100 employees, cap of $50,000, all the way up to employers who have more than 500 employees, $300,000. So that's key because, if you think about somebody suing an employer for discrimination and, well, the mental anguish that I endured, I think entitles me to $5 million. I might even get a jury to agree with me that I'm entitled to $5 million. And even if the jury awards me that amount of money, the employer can go back and say, hey, there's actually this statutory limit. And then the court would then later reduce that judgment back down to these statutory limits, or maybe even below, depending on the facts of the case. Okay. For age and sex discrimination, so we haven't talked about age yet. Age is covered under the ADEA, a separate law, separate from Title VII. But for age and sex, there are slightly different rules here. So compensatory or punitive damages aren't allowed for intentional age discrimination or intentional sex-based wage discrimination. So specifically under sex wage-based discrimination that is covered under, again, a separate law, the Equal Pay Act. So we're seeing here that things get complicated because we're seeing how different federal laws, different state laws can all come into play and complicate things. So as the employer, it's incumbent upon us to understand this interplay of these laws and be able to comply. So anyway, for age discrimination or sex-based wage discrimination, those compensatory and punitive damages aren't allowed, but I might be entitled to liquidated damages, which is a slightly different way of setting out an amount that could be paid out in the event of some type of violation. In 1991, we added that jury trials, so employees should have the right to a jury trial under Title VII. Either party can actually request this, but usually the employee would be the one that requests it because it's usually easier to get a jury to be compassionate toward an employee than an employer. That's not always the case, though. But whenever compensatory or punitive damages are sought, then I'm entitled to request a jury trial. Finally, here we'll look at the Reconstruction Civil Rights Act. So this opens up additional possibilities aside from Title VII, especially if I feel like I've been discriminated against. And so we'll look at three here. These are federal laws, Section 1981, Section 1983, and then Section 1985. And I gave you some links here in my notes so you can learn more about these. But under 42 U.S.C. Section 1981, everyone has the same rights to make and enforce contracts. I should go back to say that Reconstruction Civil Rights Acts are these acts that were passed after the Civil War in this Reconstruction period where we're trying to pass laws that make black people able to participate in the economy. Because obviously people are discriminating against them. We're trying to set some federal rules saying that, hey, you can't discriminate against these people for these specific reasons. So 1981 covers people's ability to make and enforce contracts. An advantage under suing under Section 1981 is that there's a longer statute of limitations and there's no cap on those damages like we saw under Title VII. Now, it might be harder to convince a court that I'm actually eligible under Section 1981, but it's a possibility. You would really need to talk to an attorney about that. Under Section 1983, this protects people from deprivation of constitutional rights, privileges, and immunities under color of state law, which means I'm acting on behalf of the government. So this is not something that's going to be available to private employees, but for those who are working for the government. When there's a government official who's depriving me of some constitutional right. Then finally, Section 1985 has also been dubbed the Ku Klux Klan Act. It addresses conspiracies to interfere with or deprive the civil rights of others. Just another one of those possibilities if I'm finding that Title VII doesn't offer me the compensation I might be seeking, or if I've run out that statute of limitations, other laws that can potentially be considered. But again, you really need to talk with an experienced attorney dealing with this type of this area of law to understand whether that's going to be a viable opportunity for you. That's it for now. I hope you all have a great day.